He was told to return the next day. The next day he returned, and the Supreme Court at this time in history met in the old Senate chambers in the Capitol building. Congress had actually approved the building of the construction of the new Supreme Court building, but construction had not yet begun. And so the Supreme Court had 3 rooms in the Capitol building. They had the old courtroom, this old Senate chambers as their courtroom. They had an adjacent robing room around the backside of the court, or waiting room, and they had a conference room. And Noah Pardon, when he went in, was told, wait in the robing room. The Supreme Court, they're not in session, but the court is present, and will, if they've got any questions regarding your case, they will call you in. According to the court records, it was late in the afternoon. Noah Pardon, it was about 4:30 in the afternoon. Noah Pardon had beginning, according to his own writings, had been getting very dejected, did not think that they were going to hear his case. But about 4:30 in the afternoon, and all day he'd been seeing people coming and going from the conference room. He didn't know how many justices were inside. Was there 1? Were there 9? But about 4:30, he's told to enter the conference room. And sitting there in the conference room, there's only one man. He's right in the middle of the table, according to Noah Pardon in his own writings. And he was a large man, about 6'2", weighed about 270 pounds, like me, hadn't missed many meals. And he's bald on top and has red hairs on the side. His name is John Marshall Harlan, the first Justice Harlan from Kentucky. And for the next 20 minutes, Justice Harlan is told the story that I've told you by Noah Pardon. At which point, Justice Harlan cuts him off. Well, what basic federal constitutional rights have been denied your client? I'm not here to retry this case. Noah Pardon goes into the 14th Amendment's Equal Protection Due Process Clause claim. At which point, after only about 15 seconds, Harlan cuts him off again. No. You're not here to argue that. What you would like to see this court do is declare that there is a right to a fair trial in criminal courts in the state court under the federal Constitution. Noah Pardon's like, well, that'd be nice. But before he can even respond, Harlan cuts him off again and says, but this court has repeatedly had the opportunity to do this and has repeatedly declined to do so. Why now? Why this case? And for about the next 90 seconds, Noah Pardon makes his pitch. After which, Harlan cuts him off again. I've heard enough. Thank you very much. You're dismissed. No words of encouragement. No, wow, this is a historic moment. You're the first African-American lawyer to bring a case as lead counsel to the Supreme Court of the United States. No, wow, first federal habeas petition, first day of an execution being sought by us out of the state courts. No words of encouragement like, your client's going to be executed in 72 hours. We'll take this up on an expedited manner. Pardon got back on a train to Chattanooga believing his client would be hung 3 days later. He stepped off the train, and as he did so, there he found his law partner, Stiles Hutchins. And he had 2 different pieces of paper. They were telegrams from Washington. The first was a 1-page order signed by Justice John Marshall Harlan, and it is the first ever stay of an execution by the Supreme Court of the United States in a state criminal matter. The second was a 2-page document that had been sent by telegram to Chattanooga, to court officials in Chattanooga, and it was sent about 4 hours later. And it was a superseding order signed by 6 members of the Supreme Court of the United States. And the superseding order also stayed Ed Johnson's execution, but it also pointed out that the Supreme Court believed that Ed Johnson's life was in danger due to the prior lynching attempts. And the Supreme Court declared Ed Johnson a federal prisoner and ordered local authorities to protect Ed Johnson as such, pending the outcome of this case. And the Supreme Court also ordered local lawyers in the case to prepare for oral arguments within 30 days before the Supreme Court. Well, as you can imagine, this didn't go over too well in Chattanooga. The morning newspapers decried it. How horrible, it was an outrage that the Supreme Court of the United States, these men in Washington, D.C., and the words were, interfered with the justice system in Chattanooga. How dare they? These men in Washington. This is a states' rights matter, not a federal matter. They have no business. And the newspapers predicted that that night a lynch mob would come to the jail and correct this horrible injustice. We're now into the 3rd week of March. 2 months have passed. And indeed, that night, several hundred men show up at the county jail. And they got their guns, their sledgehammers. They're going to break into the jail. They're going to kill Ed Johnson. Well, you might think that, well, you know, there was all but an invitation to a lynching in the newspaper, that surely the sheriff would have snuck Ed Johnson back out of Chattanooga to Nashville, pending the outcome of the case. But he hadn't. He had left him there. Or you might think that there was this U.S. Supreme Court order that surely the sheriff would have beefed up security at the jail. Normally there would be 4 or 5 deputies on duty at night at the county jail. Maybe put 10, 20, call in the National Guard. Instead, Sheriff Shipp actually gave all of his deputies the night off except one. He left only one deputy on duty that night at the county jail. He was 72-year-old Jeremiah Gibson, who later testified he had never fired his weapon before. The other things the sheriff did that day were he moved all the other inmates off the second and third floors, packed them onto the second and third floors, left only one person on the first floor, Ed Johnson. The lynch mob leaders were told, if you come to the jail, don't do any property damage to the jail. The deputy will be there. He's got a key to Ed Johnson's cell. Get him out. You know, don't do any property damage to the jail. The other thing that happened was all the women were moved out of the county jail to the work farm that night. Well, indeed, the lynch mobbers show up around 7 p.m. They're going to break in the jail. They're going to kill Ed Johnson. But they can't find the deputy. He's afraid. He's hiding. They take their big sledgehammers and they start beating away at the big iron lock that protects Ed Johnson in his cell. Across town, a Baptist minister hears that there's a lynching attempt at the jail. This Baptist minister races to the city police chief, separate from the sheriff, and says, "Chief, grab your men. There's a lynching attempt at the jail. We got to run. We got to go stop it." And the chief tells the minister, "No, I'm under instructions from the sheriff to not be involved tonight." The minister, totally confused, realizes the National Guard is on maneuvers down by the Tennessee River, only 8 blocks away from the county jail. And he realizes if he can get into the roof of the courthouse, which is right next to the jail, if he can get into the roof, he can ring the alarm bell and that'll call the National Guard, the emergency alarm. So he races past the jail to the courthouse, up 3 flights of stairs inside the courthouse, and who does he run into? Judge McReynolds, the state trial judge. And the judge goes, "What's going on?" And the reverend says, "Oh, there's a lynching attempt at the jail. We got to ring the alarm bell. We got to call the National Guard. We've got to stop it." And the judge says, "That's a great idea, but have you been to the jail yet?" "No." "Well, maybe the sheriff's there. Maybe he's got things under control. Tell you what, let's go downstairs. You go across the street. See if the sheriff's there. If he's not there, come back. I'll hold the door open. We'll go up, we'll ring the alarm bell together, and we'll come back down and we'll stop the lynching." The reverend agreed. They go down 3 flights of stairs. The judge holds the door. The reverend goes across the street into the courtyard of the jail. And what does he find? Pandemonium everywhere. People are shooting their guns into the air. He testified later. He goes in, makes his way inside the jail. They're beating and hammering away at the iron lock. People are yelling and screaming. There's no Sheriff Shipp. He comes back across the street, and what does he find? The doors to the courthouse have been locked shut. 3 hours later, the door finally gave way. The big iron lock gave in. The lynch mobbers got Ed Johnson out, and it's a 6-block walk from the county jail to the Walnut Street Bridge. The Walnut Street Bridge spans over the Tennessee River, which runs through downtown Chattanooga. They take him out to the second span of the bridge, and they put the noose around his neck. And they say, "Ed, there's nothing you can do that will save your life. You might as well confess." And Ed Johnson's last words are on his tombstone to this day. And they were, quote, "God bless you all. I am an innocent man." And they raised his body up, and his body swung for 4 or 5 minutes. And he wasn't dying fast enough, according to newspaper reports, and they opened fire. His body was shot more than 50 times. One of the bullets finally pierced the rope from which his body was hanging. His body fell to the wooden planks of the bridge. And according to reports, a deputy sheriff walked back up, reloaded his pistol, and shot him 5 more times. The deputy sheriff then pinned a note into Ed Johnson's chest. And the note read, "To Justice Harlan and the Supreme Court, here's your Negro now, try to save him." End of quote. The Supreme Court justices